Good morning, everyone. I am at-large council member Anita Bonds, chairperson of the Committee on Executive Administration and Labor. The time is 10:35 a.m. on Wednesday, the 13th of March, 2024. I'm calling to order the confirmation roundtable to consider two nominations. First is the renomination of Renee Bowser as an organized labor representative member of the Public Employee Relations Board for a term to end on December 12, 2026. Second is the reappointment of Mary Ann Gibbons as an ad hoc management member of the Public Employee Relations Board for a term to end on December 12, 2026. Both nominations will be deemed disapproved on May 1, 2024 without council action. And therefore, we are here today to take action on these important nominations. Um, Before jumping into the background of these distinguished nominees, I'd like to provide the public with some background about the Public Employee Relations Board. The board, otherwise known as the PERB, is an impartial, quasi-judicial, independent agency that resolves labor management disputes under the governance of a five-member board. PERB resolves labor management disputes between agencies of the district government and unionized agency employees. The agency is tasked with adjudicating unfair labor practice complaints, considering appeals of grievance arbitration awards, and investigating standards of conduct complaints. I'd like to provide a background on these esteemed nominees, and then we will hear from the nominees themselves. After opening statements, we will then spend some time asking a few specific questions that relate to their qualifications to serve or continue to serve in this instance on the Public Employee Relations Board. Let's turn first to Ms. Renee Bowser. She is the organized labor representative member of the Public Employee Relationship Board. She's an attorney with over 30 years of experience practicing before the National Labor Relations Board. She serves as Assistant General Counsel for the United Food and Workers International Union and as an attorney advisor with the National Labor Relations Board. As an attorney advisor, she works in the general counsel's office and advises on issues arising under the National Labor Relations Act, unfair labor practice conduct, unit issues, and injunctions. Ms. Bowser serves in other leadership roles such as adjunct, excuse me, please, labor professor at Howard University Law School, commissioner and vice chair of the DC Commission on Human Rights. Currently, Ms. Bowser serves as an ANC commissioner and a Ward 5 committeeman on the DC Democratic State Committee. Ms. Bowser is a Ward 4 resident, graduate from Brema College, received her JD degree, and graduated magna cum laude with honors from the North Carolina Central University and obtained her LLM when she successfully, of course, published her thesis. Now we'll talk a minute about Mary Ann Gibbons and her background. Ms. Gibbons is the ad hoc member of the Public Employee Relations Board for Management. Ms. Gibbons is an attorney with over 27 years of experience in the federal government and 10 years of private sector experience where she honed her expertise in labor and employment law and collective bargaining. She serves as the general counsel and executive vice president of the United States Postal Service for 14 years, where she managed a staff of over 300 law department employees and served as counsel to the presidentially appointed and Senate-confirmed Board of Governors. Ms. Gibbons is also Assistant General Counsel for the United Mine Workers, was the Assistant General Counsel for the United Mine Workers of America's Health and Retirement Funds, where she represented the fund's management and collective bargaining and represented the entity in federal court litigation. Ms. Gibbons' experience landed her in an adjunct professorship position at Georgetown University Law Center and American University Law School. Moreover, she has published several articles. Currently, Ms. Gibbons serves in multiple leadership roles for community organizations, such as the board member of the Shrine of the Sacred Heart dinner program for the homeless and the Council for Brothers of Charity to develop housing for homeless veterans. Ms. Gibbons is a Ward 4 resident, graduated from Maryland College, received her Master's of Art from Northwestern University, and obtained her JD degree from Catholic University of America, Columbus School of Law. I look forward to a full conversation with these two outstanding nominees. And at this time, I will turn to any of my colleagues. All right. We have with us this morning a member of our committee, Councilmember Trayon White. And I'll ask you if you would like to make an opening statement, Council Member.
I'm just happy to support the two candidates today, and hear from them about their vision and continue to work to serve the District of Columbia. I've known Ms. Bowser for quite some time as a leader in the city, not just ANC, but just a voice of reasoning uh, in the community on several different important issues. And so today I want to hear from her to figure out what we can do to advance our mission in the district. I think that we are proud to have women active in service in the District of Columbia. And this is an opportunity for us to get behind that, not just with words, but with action, but continue to validate their leadership in these roles. And so I'm excited to join the hearing today. I did want to add also Miss Mary Ann Gibbons as well. So I think that it's important for us to uh, support and leadership of these two women today. And so I'm looking forward to hearing from them, and hopefully we can move forward with their full vote on the full city council. So good morning, everyone. Thanks for joining us.
Thank you very much for your comment. And now I'll ask the two nominees if they would move to the witness table so we can take their remarks. And of course, they are currently serving, and this is an opportunity for their reappointment. So therefore, we will ask them to raise their right hand so we can swear you in. Do you swear and affirm that your testimony and any statements made before us today are truthful and complete? Thank you. Thank you very much. And we'll start with Ms. Bowser. We're going in alphabetical order, as you have noticed, and we'll take your statement. We have water coming. Yes. Yes, I'm having the yes, thank you. Um, press the button and the red light comes on, you're on.
Okay.
All right. There
Thank
you
you.
go.
Morning, Chair Bonds and members and staff of the Committee on Executive Administration and Labor. My name is Renee Bowser, and I'm gratified that you are considering my renomination to serve as the labor member of the DC Public Employee Relations Board. I'm grateful to Mayor Muriel E. Bowser for renominating me and honored to have this opportunity to serve the residents of our district. I have a varied and extensive background in addressing worker issues in the workplace. I served as a neutral anti-discrimination investigator at Pennsylvania Human Relations Commission for 6 years. In that job, I gathered evidence to determine whether a complainant had established a prima facie case of discrimination whether the employer offered a non-discriminatory reason for its conduct, and whether there was evidence of pretext. I represented workers as a Service Employees International Union steward when I worked for the state agency. Following law school, I worked at National Labor Relations Board in the Division of Advice. There, I worked to decide novel and interstitial issues in unfair labor practice cases under the National Labor Relations Act and determine eligibility of cases for injunctive relief under NLRA Section 10J. Upon leaving NLRB, I worked for more than 30 years in the United Food and Commercial Workers International Union Legal Department to provide legal representation to workers aspiring to form unions, and following their winning representation, I worked to advance their rights, pay, and working conditions. I also represented UFCW International in its role as employer in its relationship with the unions who represent the union's workforce. Throughout my career, I have benefited from representing workers from around the world of every race, ethnicity, and gender orientation with careers as diverse as nurses and packing house workers. My years of experience increased my understanding of employment systems, clear functioning personnel standards, and the importance of workers' rights, good faith bargaining between unions and employers, just cause discipline, and diverse and discrimination-free working cultures. I want to continue volunteering on the PERB board because I'm passionate about labor law and securing workers' rights. Additionally, both workers and agencies need clear explanations and roadmaps concerning bargaining relationships and the appropriate conduct that forms such relationships. I believe my background matters because I have engaged in diverse workplace matters from different vantage points as an employee union representative, a neutral employment investigator, a neutral lawyer for the National Labor Relations Board, a legal representative for workers, and a management representative in disputes between my employer and the representative unions. My background has great impact because it has afforded me deep knowledge of the National Labor Relations Act, to which PERB continually looks for guidance, and related federal labor laws that govern employee rights and responsibilities. My background has also taught me that the ability to consider various vantage points from which different stakeholders, unions, workers, employers, will view PERB decisions. I believe that my professional background will continue to allow me to help shape decisions regardless of outcome that are acceptable to the parties because of their clear presentation and reasoning. My vision for PERB in seeking reconfirmation as a labor member is still to enhance our labor management dispute resolution system, district workers, workplaces, and the broader community that is just, effective, and timely for all. Also, I have worked collaboratively with my board members in examining the facts, engaging in comprehensive research, and closely analyzing the parties' positions, just and timely decisions in the cases in which I participated. Additionally, I have endeavored to work collaboratively with my board colleagues to ensure that the Comprehensive Merit Personnel Act continues to adapt to emerging conditions brought about by burgeoning technology and changing workplace issues. I believe the ongoing education programs conducted by PERB help workers and management alike to better learn the legalities of employee and management rights and the practicalities of positive collective bargaining relationships. Moreover, I continue to support PERB's use of mediation as a timely system to protect the rights of all parties while encouraging settlements. An area that I'm interested in further exploring is the applicability of the term concerted activity as it is used in PERB case law. It may be beneficial to clarify whether and to what extent PERB has incorporated the concept into the Comprehensive Personnel Act and from the National Labor Relations Act. If confirmed, I will dedicate my passion, legal experience, and commitment to the district community to do the best job possible for PERB. Thank you for this opportunity to appear before and your consideration of my nomination. This concludes my testimony. I welcome any questions you may have.
Thank you very much for your testimony. And now we'll hear from Ms. Gibbons.
Good morning, Chairperson Bonds and members of the committee. I too am honored to come before you for your consideration of my reappointment by Mayor Bowser for membership in the District of Columbia Public Employee Relations Board. I'm very thankful to Mayor Bowser for nominating me for this appointment and also grateful to the committee for holding this hearing. I've been a resident of the District of Columbia since 1978, and I actually live in Ward 1, not Ward 4. Just want to make sure that the record is clear. I received my JD from Catholic University of America in 1980 and spent my first 5 years as an attorney at the United Mine Workers of America Health and Retirement Funds, and the last 27 plus years of my full-time legal career at the United States Postal Service. After 7 years as a staff attorney at the Postal Service, I was promoted to a management position and ultimately appointed as general counsel of the Postal Service in 1999. I retired as executive vice president and general counsel at the Postal Service in 2013. Along the way, as you mentioned, I taught as an adjunct professor at both American University and Georgetown University Law Schools, and also served on the Board of Visitors of Catholic University Law School for several years. Over the years, I have volunteered with a number of local organizations that provide services to the homeless and low-income people. Currently, I serve as a volunteer for a transitional housing program run by the Brothers of Charity, and I'm also a member of the board of directors of the Mount Pleasant Village, which is a community organization in my neighborhood. I also provide legal assistance to my husband's property management business. Next, I'll address my suitability for the Public Employee Relations Board. My first appointment to the PERB was in 2017. Service on the PERB since that time has fulfilled a longtime desire of mine to contribute to a city I've called home for many decades. The Public Employee Relations Board is an excellent match for my skill set because labor and employment law is my area of legal expertise and where my passion lies. I've been a member of a union, a legal advisor to management, and have also had the neutral role of interpreting the language of pension and health benefits plans overseen by a 3-person board of trustees composed of 1 trustee appointed by the United Mine Workers of America, 1 trustee appointed by the coal operators, and a neutral trustee agreed upon by the other 2. Before entering law school, I served on the faculty of Millersville University in Pennsylvania for 4 years and was a member of a union. At the United Mine Workers of America Health and Retirement Funds, I represented management of the funds in collective bargaining with the fund's employee union. As a staff attorney at the Postal Service, I litigated before the National Labor Relations Board, the EEOC, the Merit Systems Protection Board, and in federal courts throughout the country. I also prepared legal opinions and taught classes on various legal and employment issues. As a manager at the Postal Service, and especially as general counsel, I analyzed trends in litigation and recommended steps that would resolve legal issues more quickly while also being fair to employees and postal management and more cost-effective for the Postal Service. Next, moving on to my desires for the Public Employee Relations Board during what is hopefully my next term. As a member of the Public Employee Relations Board, I've used my years of experience in labor and employment law to analyze issues that come before the board in a skillful, fair, and impartial manner. I will continue this approach as a member of the PERB. I'm proud of the work of the PERB and the care we take to render our decisions in accordance with the law and in a way that is clear to the various readers of our decisions. During my time on the PERB, I have focused particularly on how expeditiously matters move through the PERB process and on issues that recur, particularly if they arise from the same agency. My belief is that the failure to resolve disputes expeditiously can negatively impact an individual's livelihood and employee morale, can reduce productivity in the workplace, and can add cost to the bottom line. During my next term on the PERB, I will continue to watch for delays in processing matters that come before the board and for ways to improve efficiency and timeliness in the work of PERB. During my next term on the PERB, I will also continue to focus on recurring issues and, along with other board members, will work to find ways to highlight these issues. The PERB has addressed these type issues through its excellent training program for both management and unions, by the statistics it maintains, and through the language we include in our opinions. When the PERB board has seen an unusually high number of similar matters coming from a particular area of the DC workforce, we have asked the PERB executive director to reach out to the agency involved to offer training. We've also included language in our opinions to note recurring issues, and I will continue to support these efforts. Since my initial appointment to the PERB, we conducted a thorough review of the PERB regulations. That review included opportunities for comment by all interested parties and at least one public hearing. After reviewing input from PERB staff and stakeholders, the board issued a revised set of regulations designed, among other things, to improve the efficiency of our processes. If further regulatory improvements are needed, I will support an effort in that regard. As you likely know, the PERB executive director recently retired, and the board has appointed an acting executive director and is in the process of securing applications for a new executive director. Thus, early in my next term on the PERB, I expect the selection process to be an important part of our focus. Thank you again, Chairperson Bonds and committee members, for holding this hearing. And again, I extend my thanks to Mayor Bowser for nominating me for another appointment to the Public Employee Relations Board. This concludes my testimony, and I would be happy to answer any questions you may have.
Well, thank you to both of you for your comments. I really appreciate hearing about the work of the board. So frequently, we are bringing someone new to a board. And so it's not about the work, it's about, their characteristics and their interests and how they see the organization moving forward. So thank you very much for that. The PERB is definitely one of the sterling agencies in our government because it is about the employees and how we get work done on behalf of the community. So I thank you for that. We could pretty much, in my opinion, end the hearing now because we have great testimony before us, but that's not how it works, as you well know. So I do have a few questions, but I wanted to turn to the comments that you made. I recognize that both of you have indicated concern about the timeliness of getting decisions made and back in the hands of those who you're making decisions about. And I think that is an area we're very concerned with just throughout the government, to be very honest. We tend to be a tad slow there. And I don't know whether it's because of the government, they say red tape takes forever. I learned that years ago, but as a part of the process, can you give me some ideas about what the real time is like from start to finish as you're reviewing a case and then ultimately having to adjudicate it?
Well, it can go fairly quickly within a couple of months, but reasons that it can be delayed. So of course, as a review of an arbitration review request, that would be a very typical thing that the board deals with. So first, the person wishing to appeal files the appeal. Then the responding party, whether management or the union, would respond. It could work its way to PERB at that point, but then there could be requests for extension of time by the parties, which typically, if they're reasonable, would be granted. So that can also slow it up. Then it would come to the PERB. Depending on how complicated the case is, it may take staff a while to research the issues. That could be a month or 2 months. It could be more. And then a draft decision would come to the PERB. Frequently, we are ready after discussing the draft decision, to render an opinion. But there are times when we're not comfortable. There's an issue that we think needs more research, or we may disagree with the decision and send it back for more research. So that could add another month or two. So I think I'm now up to it could be between 3 months, it could be 6 months. Then, of course, we render a decision. If the losing party's unhappy, they can appeal that decision to the court. That could then hit more time, because depending on how the court rules, it could come back to us. It could go up to the higher court. So it really depends case by case. But I know certainly when I see, and I know that Ms. Bowser has also, if something seems like it has dragged too long at the staff level, I will always ask, why has it taken this long? And then sometimes the answer is revealed in the kind of steps that I mentioned.
My concern here is not so much of the steps when it reaches PERB, because the steps and the processes that Member Givens outlined, they have to vary because of the situation. What my concern is that during collective bargaining and discussion among the parties, even before it gets to PERB, the delay is sometimes a tactic to delay getting to a conclusion, whether it's in collective bargaining. Delay can affect the parties. If one side delays in responding to the other side's proposals and vice versa. That's what I've seen. Most recently, we had a case where the issue was the types of remedies above and beyond just back pay. And yet it took the employer, one of the agencies, 6 to 7 months to give back pay. And it was agreed to, the back pay was not an issue in dispute, the regular back pay of the salary. And so you can have delay that exacerbates the system and may even exacerbate the justice of the system, because if someone's been out of work and been determined to have been denied their jobs wrongfully, you shouldn't have to wait 6 months after the PERB decision when that issue is not being appealed. Some other issues of compensatory damages were being appealed. But the back pay should be able to go forward. And that was an instance of, that was problematic, I thought.
And I would just add, if I were advising management of the district, I would say it is a problem not to take action quickly, because the impacted employee is likely very upset and distracted from their job. They are also likely chatting to other employees. So now more people are upset, and that is all a loss of productivity. There's also the case with back pay. The more you wait, interest can be added on back pay. So ultimately, the city has to pay more money than they would have if they acted quickly and got it over with. And they will have avoided the likely loss of productivity in the workplace because of the chatter and upsetment by employees.
I agree.
I appreciate hearing your perspective on this. I'm not happy to know that it takes 7 months to get back pay, because it does those kinds of actions. That timeline certainly erodes confidence in, our government. And previously, I've heard that more about the timeline for getting things done when we are doing more operational activities that affect the general public. And so to learn in this new role, because this is a new committee for me, that we've got those kind of situations also unfolding inside the government. I think it sends an alarm. And furthermore, this committee is concerned with how do we address return to the workplace to get work done, which we'll be examining, more closely in May and June, once we get the budgets behind us. So your comments are very important. I appreciate hearing from you. Thank you so much for that. I have one other area based on the testimony you shared that I wanted to examine if we could. In addition to time, you mentioned, Ms. Gibbons, that you were talking about the initial appointment and you conducted a thorough review of the regulations, and the review indicated opportunities for comment by all interested parties and at least one public hearing. Talk to me about how you see PERB doing a public hearing that could be beneficial to the general community so that they learn how we get matters resolved inside government.
Well, on virtually a monthly basis, PERB has a training course that's open to both management and the unions. I believe PERB would welcome any member of the public to come to that training course, and each time there's a different topic that is covered. So that's a very good way for members of the public to learn about the work of PERB and also the law that applies. It's also the case, particularly with a pro se complainant who, may not understand the regulations in the law. Historically, the executive director, and I'm sure the acting executive director would do the same, they'll allow the person to come in so they can sit them down and explain the process, because it can be intimidating if you're not familiar with the process. So that's another way on an individual basis that the public can learn about how the PERB works. I think we can talk as a board about whether there is an additional sort of public educational program that we could put on, so that if any member of the public who maybe doesn't have a complaint or is not a union member or management member could come and just hear about the work of PERB, of the PERB.
Okay, I think it's a good idea.
I think that's a good idea as well,
Yes.
because I think that there could be just a kind of a training or explanation program on something like DCTV, because people watch that, because people don't know. I've talked to people and they really don't know what PERB is. And just in general, they don't know what employee rights and responsibilities are.
Yes, yes. Well, thank you. Okay, we finally, now I want to turn to Councilmember White. If you have questions, Councilmember.
Thank you, Chairwoman Bonds. No, I don't have any questions at this time.
All right, thank you very much. I have a few other questions. This is always exciting. What do you consider to be the top 2 accomplishments that have occurred on the board during your appointment? Ms. Bowser, okay.
Well, one case that's basically still pending, I thought it was important to really discussing the right line decision, the right line case, and its progeny. That notion is from the National Labor Relations Act, and we weren't clear that the hearing examiner applied the right line standards properly. And this was a situation where a 8 or 9 year employee had had a good work record, and upon becoming the union rep for her shop, her performance allegedly plummeted. And so the right line test and properly applying it became crucial. I was very glad that we decided to remand to the hearing examiner to make sure that that doctrine was applied properly, because it meant someone that had a good work record was going to be, if it wasn't applied properly, have that record dissolved because the worker became the building union rep.
Okay, well, let me ask you, the PERB board reviews the work of the staff,
Yes,
and then you vote on whether or not the work you receive, the decisions you, recommendations that you receive, I'll say, make sense, are appropriate.
right.
So it's in, I would just want some context to
Well,
what you were speaking of.
And that's true. This is, the right line test is whether the person,
Oh,
I'm sorry, I
okay.
didn't have it on.
All right, keep it
right-
on.
The right line test is whether the person did something wrong and whether that person would have been disciplined for that wrong if it weren't for that person's union activities. So it's a lot of evidence that has to be collected. And the reason why that stood out to me, because I've had cases in practical terms where someone was doing everything right, had a year's good work record, and once they became supportive of the union or union steward, they all of a sudden became a crappy employee. I know from years of experience that happened. So I'm looking at detail at the facts surrounding it. Because no one, even having represented the union as management with respect to workplace, I know that no one, whatever employer, union employer or other employer, no one likes to be challenged. And so the job of a union rep in a particular shop is to challenge when they see it's necessary to challenge. And so that's always, when you challenge someone, that's why we need and we have a vibrant PERB.
And I would add to that, as in terms of the work of we have 4 members right now. We are hoping we get a 5th member soon. But as far as how the board works, we each bring significant background in labor law. So that's very helpful in terms of looking at the recommended decisions by the board. When you ask what are the things we're most proud of, one of the things I'm most proud of is that as colleagues, we are very collegial. And even though we may I have a management background, Ms. Bowser has a union background, we really strive to apply the law. And that is the most important. I don't try to sway it to the management side unless, the law directs us that way. Ms. Bowser doesn't try to direct it to a union unless the law would direct it that way. So we really work very collegially. And when we look at a draft decision, we want, is it clear? Will it be clear to the people who are reading the decision, which is very important, I think, to all of us? Does it seem like the staff got the law right? And sometimes there'll be something that one of us knows because we've had a case or whatever, and we'll say, we're not sure that that's right. So could you go back and do more research? And so the way that we work together, I think, has been very effective in terms of getting to the best possible decision under the law. So when you ask, what are we most proud of? I'm really proud of the way that we've worked together as a board. That would be one of my 2 things.
And I agree with Member Gibbons, because even when whatever we're deciding, particularly if a person, an employee is going pro se, it's so important to have the decision clear because they really don't know. And so, and it's helpful to both sides to have a clear presentation and reasoning. And that's what I think I've been glad to work with my colleagues on.
All right, so I guess my takeaway, I understand collaboration and I understand making sure that there is accuracy in what is put before the board members to deliberate on and make a final decision. I'm hoping that your comments this morning are very helpful to employees that may be listening in, family members and others, because, you know, there's always this mystery about these boards that have judicial power. And what does that really mean? Because as you say, it's about a livelihood of an individual. And it's also about, you know, making sure that we have laws in place that make sense. And that can be followed. So I'm very interested in that. I will not deliberate on, we won't have to go into that in any detail. I was thinking for a minute, I said, oh, this is a great time to talk about the relationship of the shop steward to the whole piece, and we'll unravel this mystery about the unions and how they operate, and then how the government agencies operate. But that would take us, what, a week or so? Probably. And so that would be unfair to our listening public, because I can tell from, you know, what you have shared with us and from your resumes that you know the business, and that's very important to the work that you have before us. So I will ask, and I want to put on record, as you know, the paperwork that we received from the office somehow had your reappointment titles as public members, and I wanted to be clear. That's why I made a point of specifying the role that you serve. And of course, Ms. Gibbons, you made it even clearer by saying, this is employee and I am management, but we work collaboratively. So thank you very much for that. And you've talked a lot about your decision-making methodology. Is there anything that you would like to add? Like, for instance, what happens when you receive a package and you're from the staff, you're looking at it, and as you say, you think you need more research. Do you have the authority to instruct the staff to look closer, rewrite an opinion that they have provided to you? And I wonder, how frequently does that happen? And third part is, would you say a majority of your decisions favor management or favor employees in the past FY year of 23?
I don't know the count, whether they favor management or favor employees or the union. I mean, sometimes the union is sometimes an employee is against their union. So I don't know the count of any of those three categories.
Right.
And with respect to, we get a packet of the evidence and the hearing examiner's rulings or the arbitrator's rulings, and we go through that. There may be sometimes that we may need to actually look at the transcript of the hearing or the arbitration, so we can get that as well. And we each of us do that on our own, and then when we come together, we send, even before we come together, questions that we have with respect to the facts or the law, and we discuss that and decide together whether we're going to ask more questions or make some edits to the way the decision is phrased.
And we certainly have the authority to send matters back for more research, for a rewrite. And frequently we'll have minor changes if we agree with the decision and we've sent it back for rewrite. Now we agree with the rewrite. We have an opportunity after we vote just to say, did the rewrite get what we wanted done? Did it get it the way that we wanted it done? And are there any final edits? So we're very conscious of making sure that the decision is legally correct and very, very clear.
Right, even if the decision doesn't change, that it's explained maybe more pointedly or more precisely so that the parties can understand how we got there, even if it's against them.
During FY '23, do you, either one of you, can remember the count of cases that came before you? I note that I found a file that indicated over 1,000 cases have come through PERB. And so I was just curious, not in one FY year, sorry, don't want to mislead you on that, but just, during the establishment and the record keeping process, over 1,000 cases. And I wondered if the volume of cases has increased in recent years.
I can't comment on
Yeah,
that because I've only been in
my-
2021.
Right.
When I first got on the PERB, there was a significant backlog of cases, and I think they had already been cleared up significantly by the time I got on. Then we redid the regulations, which I think help with processing. I think the volume has slightly decreased, and I say that because our staff has decreased since I first got on the PERB, and it has decreased to match the volume or the level of work. So somewhat of a downward trend.
All right.
I think it's because of COVID. I mean, there were a group of cases challenging the emergency rules that were put in place by the mayor. But I think overall, the number of cases went down during that period.
All
But
right.
historically I think about my 7th year, they have gone down to some degree, and the staff has also gone down to match the level of work.
Right. Well, I would say that makes sense. However, with the new mayor's order, bringing everyone back physically, I would imagine your job is before you.
Yeah, I think it's gonna, probably increase.
Yeah. And so that leads me to wonder if, I know you're a 5-member board, but would you need more members in order to cut through this 6-month review and decision-making process?
Well, see, we haven't, since I've been on the PERB board since June of 2021, when I was first confirmed, we've only had 4 members. So I think if we had a full board, that would be really good.
Okay.
And then we could take it from there. I mean, if the cases increase exponentially, then we could give you rethink that and
Okay.
review that with you. But right now, we've been operating with a 4-member board, and during the period when board member, was it Warshaw? Was off for about a week. Mr. Winkler was off because he had not been reconfirmed at that time. We were down to 3.
So I think I think the size of the board at 5 is fine, but as I agree with Member Bowser, it is important to have 5 because if somebody is sick or passes away, unfortunately, we need at least 3 people for a quorum. So it's good to have 5. I think if the number of cases increases, that would impact the number of staff members that we need mostly, not the number of board members.
Okay. Appreciate that. Can you elaborate on reoccurring issues that the board faces, and what role have each of you taken to address those issues if they were addressable?
Since we don't manage the agencies, well, we can't address it that way, but sometimes the same agency will have the same issue come up. They will lose it every time, and then it keeps coming up. So that's when I focus on recurring issues, I wonder, why did the agency not pay closer attention to the fact that they're losing for the same reason every time? But what we of course are not managing the agencies. We're a neutral body. So at times we have said in our opinion, this is the, third time, fourth time, or whatever, that we've seen this issue. So I think we certainly could do that. We also then wonder, does one party or the other not understand the law? And so maybe they need training. So I know we've had some times when we've asked the executive director, could you please call and offer training, whether specifically just for that agency or invite them to come to our monthly training so that if they understand the law better, then maybe they wouldn't make the same mistake twice, or on a union side, keep filing the same complaint that they keep losing. Maybe they would understand that this is really using your attorney's fees, using your time or whatever to process these complaints. So that's when I focus on that. That's what I look at.
I appreciate that. Thank you for that. I have a few questions that I'm required to ask each of you, and so I'll start. Do you or does any member of your immediate family have any interest, financial or otherwise, that may directly or indirectly pose a conflict of interest for you in the performance of your duties?
No.
No.
Okay, both have indicated no. Have you ever been investigated, disciplined, or cited for a breach of ethics for unprofessional conduct by or been the subject of a complaint to any court, administrative agency, professional association, disciplinary committee, or other professional group?
No.
No.
Have you ever received a written warning, been officially reprimanded, suspended, or disciplined for misconduct in the workplace?
No.
No.
And have you ever received a written warning, been officially reprimanded, suspended, or disciplined for violating a security rule or policy?
No.
All right. Well, I thank you very much for your time today. Pleasure having an opportunity to talk with you. And I hope that when we get into the meat of this issue of moving forward with, an open government with employees in the workplace, that you'll also come and have an opportunity to share your opinions and your visions.
Thank you.
Thank
So
you very
thank
much.
you. So Councilmember White and others who may be listening, this concludes today's roundtable. Thank you again to our nominees and to everyone who was.
Thank you.
All right,
All
excellent.
right.
Members of the public who wish to submit any comments on these confirmations on the council hearing may use the council hearing management system, or they can email it directly to seal@dccouncil.gov, and that's CEAL. The public record on this matter will remain open through Thursday, the 14th of March at 10 a.m. And let me explain, because we're going to try very hard to do a markup rather quickly. The next meeting of the Committee on Executive Administration and Labor is the opportunity to conduct a markup on Friday, March 15th, 2024 at 11 a.m. So we want to move your paperwork as quickly as possible. And so thank you very much for joining us today, and I hope it was painless.
Thank you, Chair Bonds. Thank you so much.
Always a pleasure. With that, the time is 11:30 a.m., the same day we started on the